By far and away, the number one question that we get during our free consultation sessions after car crashes in Virginia is, what is my case worth? And by far and away, the number one answer that I'm giving is, I don't know. Well, how can that be? I'm a personal injury lawyer. I've been doing this for 17 years, handling cases all across the state of Virginia. How can I not tell you what your case is worth in the initial session? Well, the main reason for that is most of the people who are coming to me for an initial consultation are still in medical care, and I don't know the extent of their injuries. If you were in a crash 5 days ago, I don't know if you're going to be better tomorrow, and some people are, or never, and some people are. And so what I want to do in this video is walk you through the categories of damages that we have in Virginia that'll help you get fully and fairly compensated for your injuries. And that fully and fairly compensated is an important piece of language. The law chooses its words very carefully. And the words that it chooses when it instructs a jury or instructs a judge about what to award you after a car crash are fully and fairly, right? And you only get one shot at your compensation, whether it's through a settlement agreement and a release with an insurance company or having it heard by a judge or a jury. You only get one resolution, and you can never ever come back and ask for more money. After you've signed the release, you can never come back and ask for more money. After a jury gives you an award, you can never come back and ask for more money. It's one shot. It's the rule of finality that keeps justice spinning, I guess. And so that's why it's important for you as the plaintiff or as the auto accident victim to understand what are all the categories of things that you can get compensated for. And in Virginia, in most cases, what we're talking about is your medical bills, your lost earnings, and your pain, suffering, and inconvenience. There are other categories of damages like scarring and disfigurement, which thankfully, they're not common in car crash cases. It's a very small subset of cases where we're talking about scarring and disfigurement. Most cases, we're talking about your past medical bills, your past lost wages, your past pain and suffering. In some cases, we're also talking about your future medical bills, your future lost wages, and your future pain and suffering. But the vast majority of cases, it's all going to be in the past. So how do we calculate those things? Well, in Virginia, it's important to know we have something called the collateral source rule. And that means that the person who caused your injury doesn't get the benefit of the fact that you had health insurance or that you have medical expenses that paid some or even all of your costs, okay? If you have a health insurance policy that's paid your medical bills and you've only had to pay co-insurance or co-pays, well, the defendant in that case, or the insurance company in that case, is still on the hook for whatever the retail price of your medicine can be. And that can really inure to your benefit if you have good health insurance. It's important to understand that, and important to understand that it's not only your out-of-pocket costs that get paid for. Well, what about PTO? If you use PTO or sick leave or vacation pay, you didn't actually lose any dollars in your paycheck, but you did lose the ability to use your future days, use your future bank of hours to keep the dollars in your paycheck the same. And so just like with the collateral source rule and your medical costs, if you use PTO or sick leave or vacation pay to compensate you while you were out of work, you still have a claim against the insurance company for whatever your regular rate of pay is. It's $25 or $50 an hour or something per diem. You still have that claim against the insurance company. Now, but here's the exception. If you are one of these work from home people and you were able to structure your life so that you went to medical care in the morning or maybe in the evening and you still worked 40-hour weeks, you don't have a wage loss claim. If you didn't lose anything, either dollars or PTO or vacation pay, you don't have a claim against the insurance company for your wage loss. You do have a claim that your life was more inconvenient, which is in that pain, suffering, and inconvenience bucket, but it's not worth $25 or $50 or whatever your hourly or per diem rate is, right? And so financially, you're better off using your PTO or using your vacation pay, keep your earnings and your paycheck the same, and then have the insurance company compensate you for it afterwards. But that's a decision that you have to make with your family based on, do I actually need to be able to take a vacation later in the year or do I not? All right, let's talk about what's called non-economic damages. So some states have caps on non-economic damages. Virginia does not. Non-economic damages are those things we can't put a dollar sign on, right? It's easy to put a dollar sign on your medical bills. It's easy to put a dollar sign on your lost earnings. It's harder to put a dollar sign on your pain and suffering. There is no rule book or statute that tells a judge or a jury what a neck injury is worth or what a broken finger is worth. And so we have to, as your lawyer, construct for the jury and paint the picture of what are all the things that you couldn't do and what was their impact on your life. Because a broken right hand has a very different impact on a left-handed person than it does on a right-handed person. It has a very different impact on a single parent who's working 2 jobs and has 3 kids at home and has to do the laundry than it does on somebody who doesn't have all of those things and all those extra obligations, right? And so part of your injury lawyer's job is to really dig into your life and understand all of the impacts that these injuries had on your life that are unique to you. So one of the things that we hear kind of all the time from a back injury case is I couldn't drive, or I couldn't garden, or I had trouble carrying the laundry upstairs, things like that. I consider those things to be largely generic, right? But if you're somebody who usually plays pickleball 3 times a week and you weren't able to play pickleball, or if you're somebody who is a bodybuilder and goes to the gym all the time and you weren't able to do that and you put on 15 pounds, right? Then those are the very specific things to your claim that you should be arming your lawyer with and your lawyer should be asking you about so they can go to the insurance company and get for you an above average settlement. Listen, insurance companies have enormous sets of data and they can say a case with $15,000 in medical costs, it usually settles within this bell curve range, or usually goes to trial and ends up within this bell curve range. And the goal of hiring a lawyer is to have them gather enough information that your result is at the top of the bell curve range. And they can't do that without input from you and gathering from you what are the things in your day-to-day life that actually cause an impact, cause you pain, cause you suffering, and cause you inconvenience, so that we can tell a great story to a judge or a jury or an insurance company to get you compensated the way that you deserve to be compensated. Now, one of the common misconceptions in personal injury work is that you have this system of jackpot justice and that a jury might award some enormous amount of money for an insignificant injuries. And I'm here to tell you, I've never seen that happen, right? What happens is a media agency reports on a story and leaves out a lot of the important facts that were heard by a jury. Jury is not in the business of transitioning wealth from one side of the table to the other. They are in the business of fully and fairly compensating the plaintiff's side of the table for the harms that they underwent. And that's why every single case is unique. And that's why you need to be making sure that you tell your lawyer everything that you've been to. We have our clients draft written statements for us. We call them damages impact statements, where they will tell us all of the things that happened to them. And I encourage my clients from the very beginning to keep a running Word document of all of their complaints so that by the time we get to a settlement with the insurance company, when we're writing a demand letter to the insurance company, we remember and we have a catalog of all the things that most people have forgotten about, because we tend to forget about all the hard things that happen in our life, right? But if you are documenting all these things along the way, then outside of your medical records, we have this very rich and vibrant set of stories that we can tell to an insurance company to command that they pay you every dollar that you're owed. If you've been in a crash in Virginia or in Maryland, give my office a call and we would be more than happy to talk about whether we can add some value to your case. If you're in any other state, give us a call and we will put you in touch with a trusted lawyer in our network who will help you with your claim.